Is the chair.
Thank you, Mr. Speaker. Mr. Speaker, when you were adjourning yesterday, a point of order was raised by a senator for Muranga, Senator Kangata, on what is contained in page 97 and page 98 of the report that has been tabled before the floor. Mr. Speaker, in my brief life, I always like speaking the truth and being very candid. And what is contained in this report is nothing other than the truth and the whole truth. Mr. Speaker, when we retreated as the joint committees of the two houses, as you can see at page 97 and page 98, we did call for the bills that were tabled before the respective houses. And Mr. Speaker, what the remarks that you can see in page 97 is the anomalies that were picked on the two bills, the one that was tabled before the National Assembly and the one that was tabled before the Senate. And Mr. Speaker, Senator Kangata was a member of our committee, and he sat as we deliberated on this issue. And Mr. Speaker, what we have, the observations we have made to the House is that there were some differences on some clauses on the bills that were the bill that was read in the National Assembly and the bill that was read in the Senate. Mr. Speaker, regarding subclause 3B, the bill that was read in the National Assembly was amending Article 97, sub-Article 2. The bill that was read before the Senate was amending Article 97, sub-Article 3. So clearly, Mr. Speaker, we did make an observation that there were differences in terms of what was being amended on the bill that was read in the National Assembly and the one that was read before the Senate. Regarding clause 48, Mr. Speaker, of the bill, we made an observation, Mr. Speaker, that whereas the bill was amending Article 188, on the marginal notes, reference was made to Article 189. And finally, Mr. Speaker, we did make an observation that in the second schedule of the bill, Section 1, subsection 1, the bill that was read before the National Assembly was amending Article 89, sub-Article 7. The bill that was read before the Senate was amending Article 87, sub-Article 7. So, Mr. Speaker, plainly, and I hope members have read this report, what we are telling the House is that the bill that was read before the Senate has some errors on the face of the record. And we have made a proposal, Mr. Speaker, that this House, and that is at page 65, this House should take legislative action to correct the errors of form that appear on the bill. So what we are saying, Mr. Speaker, is that the person who has moved this bill, that's the majority leader, has an option, Mr. Speaker, of moving an amendment to correct the error of form. And if you read the report, Mr. Speaker...
Let's consult in low tones, You know, what is raising a very important matter, Honorable.
Mr. Speaker, if you read this report, we had two experts, Mr. Speaker, Professor Kamiri Mbote and Dr. Collins Odote. And they did point out, Mr. Speaker, that if we identify an error of form, not an error of substance which changes the wishes of the promoters of the bill, we can make steps to amend the bill to correct those errors. Mr. Speaker, I want to state that I'm not the author of the errors that appear in this bill. I'm not the author. And I've seen debates on social media that there were two bills. Whether there were two bills or one bill, I don't know. The only business that we had to undertake as a committee is to scrutinize each clause of the bill, make observation, and report back to the House. And Mr. Speaker, I'm sure that even His Excellency the President and the Right Honorable Prime Minister, the owner of the handshake, they are not going to kill any of us if we correct this mistake on this bill. Nobody is going to say we have committed a mistake by correcting this error. And Mr. Speaker, I want this House to note that the bill that is being considered at the National Assembly does not have these errors. So don't look at what is happening on the other side. The error on this bill refers to the bill that was read before the Senate. So the task of seeing how to correct those errors is only with this House. And Mr. Speaker, we have proposed that the leadership, that is the move of this bill, takes steps to correct that error. How will we look to the Kenyan people, Mr. Speaker, if we consider a bill that has got these typing errors, and we fail in our duty as members of the Senate in correcting these simple errors? And then you send a bill to the people that has got these glaring errors. Mr. Speaker, I want to persuade the House that this is an error that does not change the substance of the bill. So we are not changing the intention of the promoters. We're just doing an amendment that will correct errors that appear on the face of the bill that was read before us. So, Mr. Speaker, the next point I was making yesterday was regarding the clauses on the judiciary. And Mr. Speaker, some people did not get the point I was making. Mr. Speaker, if you read Article 172 of the current Constitution, the Judicial Service Commission still retains the power of considering complaints that are made against judges. And I want to read what is in Article 172C. It says that the function of the JSC will be to receive complaints against judges, to investigate and remove from office or otherwise discipline registrars, magistrates, and other staff in a manner prescribed by an act of Parliament. Mr. Speaker, the current position is that you cannot suspend a judge of the High Court, Court of Appeal, or the Supreme Court before Judicial Service Commission has recommended to the President the setting up of a tribunal to look into the conduct of a judge of a superior court. Now, the clause that that the committee has an issue with is what is in clause 43, Mr. Speaker, whereby it is now proposed that just by the mere receiving of a complaint, before that complaint is looked at and a determination made that a tribunal should be formed to look into the conduct of the judges, Judicial Service Commission can now suspend a judge. And then later on even say we have looked at the complaint and we have found it unmerited, and you are free to go back and perform the functions of your office. What we are saying as a committee, Mr. Speaker, is that this will be a big clawback on the independence of the judiciary. It will create a lot of fear among judges, and we are proposing that the prevailing situation where judges are suspended only after a recommendation has been made to form a tribunal should remain as it is. That's why we have termed that particular amendment to the Constitution as being unconstitutional. But Mr. Speaker, the other clause that we looked at was clause 203. Now, Mr. Speaker, on this particular one, there is a proposed amendment to this Constitution in clause 50, Mr. Speaker, where there is a new clause, that is clause N, and I could read that close to the House, which reads, to ensure that the average amount of money allocated per person to account with the highest allocation does not exceed 3 times the average amount per person allocated to account with the lowest allocation. Mr. Speaker, if you look at the findings of the committee, and this is at page 166 of our report, Mr. Speaker, we have analyzed this provision vis-a-vis clause Article 217 of the Constitution, which provides that in every 5 years, the Senate will come up with a resolution to determine the basis for allocating money among counties. And Mr. Speaker, we had an assimilation that was done to us by the Parliamentary Budget Office. And Mr. Speaker, if we were to apply that new clause, 203N, there are a number of counties that will automatically be disadvantaged. And a county like Tana River will immediately lose 2.3 billion if that clause was to take effect. A county like Samburu will lose 1.2 billion. A county like Marsabit will lose 1.2 billion. A county like Isiolo will lose 1.1 billion. Lamu will lose 435. No, Turkana will lose 435 billion. Taita Taveta will lose 368 million. So this is a matter that you may not see this debate being vibrant in the National Assembly, because this is a matter that is handled almost exclusively by the Senate. It's us who understand that our role really is to defend county governments and the people who reside in those counties. So when we look at all these factors, Mr. Speaker, and considering the fact that the last resolution that was passed by this House stated very clearly that no county should be allowed to lose money, we made a conclusion, Mr. Speaker, that this proposed Article 203N will be in clear conflict with the provisions of Article 217 of the Constitution. And we said, Mr. Speaker, that should this bill pass, then the executive and Parliament will again be called upon to put in place mechanisms that will ensure that no counties are disadvantaged. So we made a conclusion that that article, in our opinion, is problematic, is undesirable, and that it will interfere with the provisions of Article 203(1) of the Constitution, more so on issues of affirmative action, whereby, Mr. Speaker, some of the counties that have been lagging behind in development must be supported with more resources so that they catch up with other parts of Kenya, and that we must also ensure that there is a stable and predictable allocation of resources to counties. Mr. Speaker, if these counties were to lose this money, it will make their budgeting and financial planning to be almost impossible. Madam Speaker, the other clause that we looked at is clause 230. I mean, the proposed amendments to clause 230, that is the one that deals with salaries and remuneration commission. That is clause 61 of the bill. Mr. Speaker, if you look at the current architecture of that clause, clause 230 of the current Constitution, Article 230 of the current Constitution, Mr. Speaker, the composition of SRC includes one representative of the Parliamentary Service Commission, one representative of the Public Service Commission, one representative of Judicial Service Commission, one representative of the Teachers Service Commission, the National Police. Then the Senate picks one representative on behalf of the county governments. And then we have one representative representing the trade unions, one representative representing employers, and then one representative representing the Joint Forum of Professional Bodies. Mr. Speaker, having having listened to stakeholders, and I must say that one of the stakeholders was Senator Kasanga, who appeared before us. Mr. Speaker, an issue arose that this proposed amendment to Article 230, where all these bodies will be removed and then replaced with 7 commissioners, picked by the President and then vetted only by the National Assembly and not by the Senate. Yet, they will set terms for both members of National Assembly and the members of the Senate is highly objectionable. Mr. Speaker, we also looked at how SRC will be able to determine terms for professionals, including engineers, quantity surveyors, providing service to county and national and county governments. And we found that this article will most likely be very problematic. And therefore, Mr. Speaker, we propose that in future, there will be need to relook at this particular article. Now, Mr. Speaker, the other point that was very controversial is the second schedule of this proposed bill. Mr. Speaker, on the issue of the proposed 70 constituencies, we looked at it from two angles, Madam Mr. Speaker. The first one is the process leading to the creation of the 70 constituencies. And Mr. Speaker, we went through all the BBI reports, and they are contained in this report that was tabled before the House. And Mr. Speaker, we looked at the initial task force. When they released their first reports, there was nowhere where there was a mention of an additional 70 constituencies and the 28 counties that were to benefit. The task force that was appointed to validate the report that was released by the first task force never mentioned these 70 constituencies anywhere. Mr. Speaker, the MP for Bobasi, and I will not refer to the exact page because of time, and the senator for Kitui appeared before the committee during the public hearing, and they took us to task, Mr. Speaker, to show them where the BBI team held public hearings, where Kenyans gave views as to which county should benefit from these 70 constituencies. And Mr. Speaker, we had no answers. Therefore, the process that was followed to allocate these 70 constituencies to 28 counties and leave out 19 does not have answers within BBI. Number 2, Mr. Speaker, we invited 2 critical bodies, Kenya National Bureau of Statistics and Independent Electoral and Boundaries Commission. Madam Speaker, when Kenya National Bureau of Statistics appeared before us, they took us through the population data in their possession, and then they took us through the formula of population per constituency that can be used to share out these constituencies. Mr. Speaker, their verdict, and it is here in this report, was that at least 5 counties were unfairly denied constituencies. They identified the county of Kitui, they identified the county of Kisii, they identified the county of Meru, they identified at least in total 5 counties. And Mr. Speaker, they said if we used a proper formula, those counties should have been allocated additional constituencies. So, Mr. Speaker, when we asked IBC whether they were consulted, whether there was any public hearings before these constituencies were allocated to these 28 counties, Mr. Speaker, IEBC appeared before us and stated, and it is in this report, that they were never consulted and they were never involved on the allocation of these 70 constituencies. Now, what is even serious, Mr. Speaker, is that IBC told us that BBI task, Mr. Speaker, I hope you can add me more time, 10 minutes.
No.
Now, Mr. Speaker,
order. You know,
when,
just a minute. You know, when they ask the speaker, not everybody is a speaker. So I hear, I am following. I'll add him 5 minutes.
Thank you. Yeah. Mr. Speaker, those who read the report, they can look at the submissions by the senator for Kitui at page 147 and the MP for Kisii at 147. So what IBC told us, Mr. Speaker, is that page 147, what IBC told us, Mr. Speaker, is that under the provisions of Article 88, Sub-Article 4, and Article 89, Sub-Article 5 and 7, they are the only ones that have the constitutional mandate of delimitation of boundaries. And even then, they told us, Mr. Speaker, that they only do so after they have accorded an opportunity to all Kenyans to make their views on those constituencies. And then they told us, Mr. Speaker, that even after the exercise has been concluded, invoking the provisions of Article 89(10), they still must give another leeway for any dissatisfied Kenyan to go to court and challenge that process. And the judiciary is given a period of 3 months, to resolve that dispute. So what IBC told us, Mr. Speaker, is that what is provided in this second schedule, which gives them a period of 6 months to undertake that process, is not practically possible. Taking into account all those provisions, Mr. Speaker, and the fact that a schedule cannot purport to amend substantive provisions of the Constitution, the committee arrived at a finding, which is in this report, that the second schedule that proposes to allocate constituencies to 28 counties and leave out 19 is unconstitutional and is of no effect. Mr. Speaker, the question then arises, with all these problems, what must we do as a House, Mr. Speaker? Mr. Speaker, when I read the American history, there are two ways you can interpret the Constitution. You can choose to interpret the Constitution in so much a restrictive manner that this House will more or less be moribund. You can also interpret this Constitution in a manner that is so liberal that you're able to achieve two purposes. One, you are able to correct some of the mistakes that this report has pointed out to the House. And number two, you could raise up your hands and say, the Senate, our role is to be paper pushers, we tick boxes, and we say anything which is unconstitutional will be handled by the courts. The choice will be made by us senators. We have drawn the attention of this House, Mr. Speaker, that Article 94, Mr. Speaker, was given to us by the people of Kenya to exercise legislative authority on behalf of the people we represent. If you read Article 1 on the supremacy of the people, Mr. Speaker, it says, I want to read, the supremacy of all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this Constitution. So if you invoke Article 94, you are not interfering with the supremacy of the people of Kenya. You are acting in accordance with this Constitution. I want to appeal to the House. Mr. Speaker, to correct the errors that are appearing on this bill before it is released to the people of Kenya for voting. It will be very undesirable, Mr. Speaker, for the National Assembly to pass a bill that has got clauses that are different from what is being passed by this House before we do the corrections. Mr. Speaker, with those remarks, I move. Thank you, Mr. Speaker.
Senator